This lecture would be devoted to the role of United Nations High Commissioner for Refugee in regards to the protection provided by the High Commissioner for Refugee, a kind of international protection, and it originated due to the First World War when refugees themselves were making their first entrance into international law. So they were tasked that to be entrusted by the League of Nations to the first High Commissioner for Refugees, who was instructed to define the legal status of the refugees. It was in 1930 that international protection made its official entry into the vocabulary of international affairs when the General Assembly of the League of Nations requested its competent bodies to ensure the legal and political protection of refugees. So, looking at this angle, international protection would therefore appear to be a logical consequence, a sort of corollary to the acquisition by refugees of the status of subjects of international law, the act by which a person acquires refugee status. In other words, the grant of asylum is in itself a protective measure taken by the receiving country vis-a-vis the country of origin, as it was in the past by the religious authorities vis-a-vis the civil authorities. This explains, moreover, the concern of states to proclaim clearly that the grant of asylum is a humanitarian and peaceful act. So, on this very target, the United Nations High Commissioner for Refugee was established. So, now we would like to go how far that international humanitarian organization came into. So the very resolution 428 adopted by the General Assembly of the United Nations on 14th December 1950, which established the statute of the United Nations High Commissioner for Refugees, instructed the latter to provide protection to refugees within his mandate. So, Article 8 of the statute explains what is meant by protection and gives a detailed list of United Nations High Commissioner for Refugees' responsibilities in this regard. And also under Article 35 of the 1951 Convention, the contracting states undertake to cooperate with the Office of the United Nations High Commissioner for Refugees in the exercise of its functions, and in particular to facilitate its duty of supervising the application of the provisions of the convention. They also undertake to provide United Nations High Commissioner for Refugees with information and statistical data concerning the condition of refugees, the implementation of the convention and laws and regulations in force relating to refugees. The functions of protection is mandatory for the High Commissioner. In fact, the High Commissioner is entrusted with the task of supervising and controlling the application of the convention together with the more general task of protection derived from his mandate gives him an international authority which has never been challenged and which comprises an element of supranationality. The responsibilities which he has been given with the now unanimous assent of the international community in the field of the international protection of refugees make it legitimate to look upon such protection as henceforth forming an integral part of an international law. And the very role played regarding protection is as provided under Article 2 of the Statute of the United Nations High Commissioner for Refugees, which states that the work of the High Commissioner shall relate as a rule to groups and categories of refugees. The narrow concept of the role of High Commissioner expressed the desires of governments at that time to put an end to much more extensive and costly responsibilities entrusted to the other two organizations which preceded United Nations High Commissioner for Refugees. Article 8 of the statute, which lists the tasks in the field of protection, for an explicit reference to the protection of refugees as individuals. Was this due to a deliberate desire to prohibit actions by the High Commissioner in favor of any particular refugee, or was it simply a way of formulating a general term in particular historical framework? The provisions relating to protection show the very desires of the rights of individuals, and as such, the very promotional role played by the United Nations High Commissioner for Refugees as provided under Article 8 of the statute, a role which may perhaps be described as that of a legal aid, has developed in the net arose. If protection in fact is a fundamental and permanent function of the High Commissioner, it is essential, however, that every refugee should feel that he is effectively and personally protected by the international authority as he could be by a diplomatic or consular authority. And as such, regarding the very function of the United Nations High Commissioner for Refugees as defined in the statute under Article 1, as the very provision follows, the United Nations High Commissioner for Refugees acting under the authority of the General Assembly shall assume the functions for providing international protection under the auspices of the United Nations through refugees who fall within the scope of the present statute, and of seeking permanent solution for the problems of refugees by assisting governments and subject to the approval of the governments concerned. Private organization to facilitate the voluntary repatriation of such refugees or their assimilation within new national communities. So, Article 1 of the statute assigns United Nations High Commissioner of Refugees refuses two fundamental functions, that of providing international protection and that of seeking permanent solution for the problem of refugees. So, the very protection under the earlier instruments as per permanent solution. Article 1 of the statute enumerates two things. One is voluntary repatriations and assimilation with a new national community. So, in regards to that, forced repatriation would be tantamount to expulsion, which is expressly prohibited by the convention and by international custom. Repatriation assistance may take various forms depending on circumstances. So, United Nations High Commissioner for Refugees endeavors to prepare the ground, if necessary, by freely accepted contracts between the refugees and authorities of the country of origin. Sometimes it helps refugees to obtain visas, and sometimes it bears the cost of the refugee's return travel to his country, or in case of large groups of refugees, organizes such travel in cooperation with the countries concerned. And as such, the most important task entrusted to United Nations High Commissioner for Refugee, besides repatriations, the second one is important: assimilation. If voluntary repatriation proves impossible, the only other solution is assimilation. The final aim of assimilation is the acquisition of new nationality. However, the refugee may claim this only on certain conditions and only after a certain period, which varies from country to country. In the meantime, he must pass, not without difficulty, through the intermediate stages of integration in economic, social, and to some extent cultural atmosphere of the country where it would be assimilated. This integration, whether it takes place in the country of first reception, what has become known as local integration, or in a country known as the country of resettlement, is conditioned by number of factors on which its success depends. So, the economic, social, or demographic context of the country of reception, with the possibilities which it offers for, or the obstacles which it places in the way of rapid and smooth integration, is of the fundamental importance. Other factors are the capacity of the refugees themselves, their age, occupation, state of health, and ability to adapt to an entirely new society. So, also, in regard to material assistance as provided under the statute of United Nations High Commissioner, the role of the office to provide financial help to countries of reception or material assistance to refugees. So the door was, however, left open for occasional and limited material assistance as provided under Article 10 of the Statute of the United Nations High Commissioner for Refugees, and the High Commissioner to administer any funds which he may receive from public or private sources. But it was specified that he could not appeal to governments. In other words, that nothing now or important could be undertaken in that sphere without the prior approval of the General Assembly of the United Nations Organization. And as such, in regard to the very competency of the United Nations in regarding the use of good offices by the High Commissioners, would like to discuss on four different stages. So, in regards to the first stage in 1959, the goal was the General Assembly resolution, of which it spelled out a distinction was drawn for the first time between refugees within the mandate and refugees who do not come within the competency of the United Nations, in respect of whom the High Commissioner was authorized to use his good offices in the transmission of contributions designed to assist them. So the General Assembly resolution of 1957 had already mentioned the High Commissioner's good offices as regards the Chinese refugees in Hong Kong. There, however, the action of the High Commissioner's office had been strictly confined to a specific group and had also been of clearly limited scope. Passing from this particular to general, the 1959 General Assembly resolution thus extended the use of the good offices, transforming their applications into supplementary means of action, whereby the High Commissioner could henceforth transmit contributions on behalf of any group of refugees not within the competency of the United Nations. So also the 1959 resolution does not say any such refugees were excluded from the General Assembly's original mandate to the High Commissioner's office. On the occasion of the sudden massive exodus of some 2 lakh Hungarians in 1956, for whom no individual eligibility procedure was really feasible, at least not immediately. The question whether or to what extent the High Commissioner office was competent to intervene had in fact arisen. The removal of the legal and institutional barrier to his action was accomplished by General Assembly Resolution 9, expressly requesting the High Commissioner to intervene. A similar difficulty confronted the General Assembly and High Commissioner's office when the Assembly invited the High Commissioner to intervene for the first time in Africa. This too was resolved by an express decision of the General Assembly under Resolution 10. The general circumstances, developing countries, and the total absence of the requisite administrative structure excluded, even more clearly than in the case of the Hungarians, any possibility of instituting a procedure for determining the individual eligibility of 1,80,000 of Algerians who had taken refuge in Tunisia and Morocco during Algeria's struggle for independence. Also, the need for such a procedure was all the less apparent as the refugees in question were already benefiting from a right of asylum which had been granted to them and which no one had of any intention of disputing. What they did need, however, was large scale assistance in the form of food, clothing, shelter, and so on. And in regard to the second stage, and it was in 1961 a new expression appeared in both the general resolution for that year and the resolution concerning the Angolan refugees. It reiterated in broader terms the motion of High Commissioner's good officers, and in the third stage, the final integration of the High Commissioner's good officers, and hence that of new groups of refugees into the regular mandate was reached in 1965 in resolution of General Assembly abandoning the distinction between refugees within the mandate and refugees covered by the High Commissioner's good officers simply requested the United Nations High Commissioners for refugees to pursue his efforts with a view to ensure an adequate international protection of refugees and to providing satisfactory permanent solution to the problems affecting the following year, confirmed this return to a unified responsibility for the different kinds of refugees by requesting the High Commissioner to continue to provide international protection to refugees who are his concern within the limits of his competency and to promote permanent solution to their problems. And finally, in the fourth stage, that regarding displaced persons and their gradual integration into the High Commissioner's mandate. Matter should probably have gone no further at the fourth stage, at least for this time being, if an important problem had not arisen with regard to the Sudanese refugees, for whom the this agreement finally opened up prospects of a return to their own country to facilitate the speediest possible repatriation of the 150,000 Sudanese who had taken refuge in neighboring countries and to help those who had fled to the interior to return to their homes. The General Assembly mentioned refugees and displaced persons side by side for the first time in the history of the High Commissioner's office, and that was in the resolution 2958 on December 12, 1972. So, the very use of good offices of the High Commissioner that developed in the four stages, in four different international refugee cases, such as the Chinese, the Hungarian, the Algerian refugees, and also the Angolan and the Sudanese refugees. And now we'll go to finally the coordination of humanitarian tasks. And in regards to that, the need for active cooperation and increasingly extensive coordination among United Nations agencies has long been a favorite topic for government representatives in the General Assembly and the Economic and Social Council. And rightly so, it is quote each year in the General Assembly's resolution on the High Commissioner's report. There is nothing surprising in this. Under paragraph 8 of the Statute of United Nations High Commissioner for Refugees, the High Commissioner has the task of coordinating the efforts of organizations concerned with refugee welfare as far as assistance is concerned, but not protection. Such coordination was considered for the work of the High Commissioner, deriving from the work of international and human solidarity, which is required to promote. As long as the Hungarian exodus in 1956, the General Assembly invited the governments and non-governmental organizations participating in the aid and resettlement work to coordinate their aid programs in consultation with the Office of the High Commissioner. So, in between March and December 1971, it was estimated by the Government of India that some 10 million East Bengalis had fled into the neighboring Indian region, mainly to a provincial state of the Union of India, and that is West Bengal. A humanitarian operation of exceptional scope was required. The High Commissioner was called upon by the Secretary General to coordinate the overall humanitarian operation. A decision soon confirmed by the General Assembly. This undertaking was to test United Nations High Commissioner for Refugees' ability to handle in close and regular consultation with the various agencies and programs of the United Nations system, diverse and complex situations in an atmosphere of considerable tension. The outcome would appear to be successful, for in 1972, the General Assembly requested the High Commissioner for continue to participate at the invitation of Secretary General in those humanitarian endeavors of the United Nations for which his office has particular expertise and experience. The reasons for this choice were given in the General Assembly resolution of December 1973, in which, after referring the essential humanitarian actions, the General Assembly mentioned the increasing useful cooperation between the High Commissioner and other members of the United Nations system, resulting in better coordination of action and greater efficiency in fields of common interest. As one moves on again pragmatically from the particular to the general on the basis of situations which had justified the decision of the General Assembly when it had, in specific circumstances, entrusted United Nations High Commissioner for Refugees with coordinating certain humanitarian operations. This has just been confirmed by the Economic and Social Council. So, the new dimension in the High Commissioner's activities is further confirmed in clear terms by the Economic and Social Council's resolution of 1976, where the Council recognizes the importance of essential humanitarian tasks undertaken by the Office of the High Commissioner in the context of man made disasters in addition to its original functions. So, the very coordinating role of the United Nations High Commissioner for Refugees, of course, initiate activities only within the frame of the criteria governing his humanitarian action. In so doing, he must also take into account the provisions of Article 17 of the Statute of United Nations High Commissioner for Refugees, provides that the High Commissioner and the Secretary General shall make appropriate arrangements for liaison and consultation on matters of mutual interest in view of their manifold implications of their scope and of their very nature. The overall activities of the United Nations High Commissioner for Refugees concerns the United Nations system as a whole. The Secretary General should therefore be in a position, when necessary, to exercise his prerogatives in the field of United Nations coordination at the highest level. So, in this lecture, we have discussed regarding the very origin, establishment of the United Nations High Commissioner for Refugees and those factors responsible for institution and establishment of the High Commissioner's office, and the very targets and tasks provided to the High Commissioner, and also to coordinate with the municipal legislation, and how the very legal backbones framed for the Office of United Nations High Commissioner for Refugees, and in particularly in regards to the protectionary functions of the High Commissioner. So after the institution of United Nations High Commissioner for Refugees, the main functions entrusted under the statute of the United Nations High Commissioner for Refugees. One is regarding repatriation, and the second one is relating to assimilation of the refugees, and the next one is regarding the material assistance to refugees. These are the important functions entrusted under the statute to the High Commissioner for Refugees. And in particularly, the use of his good offices, how it was used in different occasions in that connection. We have divided 4 different stages, and in relation to the first stage, we discuss the problem of the Chinese refugees and also the Hungarian refugees, and also we have discussed in the second stage about the Algerian refugees, and also about the Sudanese refugees, and also about the Angolan refugees. So in all these four different stages, how the United Nations High Commissioner's office use its good offices as per the provisions provided under the Statute of United Nations High Commissioner for Refugees. Then we have discussed the coordination in between the United Nations High Commissioner for Refugees and with governmental and non-governmental organization under the auspices of the Secretary General of United Nations General Assembly and also under the guidance and assistance of the Economic and Social Council of the United Nations organizations.